Today, we're going to focus on logical relevance under Rule 401 of the Federal Rules of Evidence, and I'm going to make 3 points in particular. First, under Rule 401, evidence must be material. It must go to a fact that is of consequence to the determination of the action. Second, the evidence must be probative. It must make the existence of a material fact more probable or less probable than without that fact. And third, under Rule 402, there is a presumption that evidence that is legally relevant under 401 is admissible unless a countervailing rule says otherwise. Federal Rule of Evidence 401, I think it's helpful to think about this rule as having 2 parts. First, the evidence must be material. It must be consequential. It must go to a fact of consequence to the determination of the action. The second piece is the probativeness requirement. A consequential fact, a material fact, must also make the existence of that fact more probable or less probable than without it. Let me use an example here to explain how Rule 401 works. Let's say I'm on trial for being a bad teacher. The prosecutor tries to introduce evidence that I watch a lot of NBA basketball games and that I'm a fan of the Boston Celtics. The prosecutor out here in Utah happens to be a Jazz fan, so he thinks it will look good to introduce evidence against me as a Celtics fan. Is that fact of consequence in the case against me for being a bad teacher? No, it's not material. It isn't. Maybe there's an argument that if I watch too many games, I'm not preparing for class, but that's truly a stretch. Let's change the facts, however. Suppose I'm on trial not for being a bad teacher, but for illegally betting on basketball games. The case against me for illicit gambling. In that case, may that same prosecutor introduce evidence of my love for the Boston Celtics and about my basketball viewing habits? Sure. Here's why. It puts me in the pool of people who are more likely to bet on NBA basketball games than other people. All things considered, someone who follows basketball is more likely to bet on it, to wager money on a basketball game, than somebody who doesn't. Does the fact that I like the Boston Celtics and watch NBA basketball games mean that I actually committed this crime? No, of course not. But does it have to in order for the evidence to be relevant? No. Rule 401 does not mandate that the relevant evidence must, in fact, prove guilt or prove some legal element in the case. Indeed, the legislative history to Rule 401 talks about how this rule just looks for evidence that is a brick in the wall of the case. The evidence doesn't have to set up an entire wall. It just has to be a piece of the case. Now, assuming that evidence is relevant under Rule 401, and it's a relatively lenient test, I like to call it a bare bones test, what is the underlying presumption? Is relevant evidence admissible or inadmissible? Rule 402 is the next rule that I want to mention. Rule 402 essentially says that relevant evidence is presumed to be admissible unless there are some exceptions out there in the rules of evidence or in some other source that suggest it should be excluded. We focused on 3 points. First, that evidence under Rule 401 must be material. It must relate to a fact of consequence to the determination of the action. Second, the evidence must be probative. It must make the existence of a material fact more probable or less probable than without it. And third, under Rule 402, evidence that is relevant under 401 is presumed to be admissible unless another rule says otherwise. Ultimately, please keep in mind that Rule 401 is a very lenient test. It is indeed a bare-bones relevance test. The advisory committee notes mention that evidence needs only to be a brick in the wall of a case. In other words, it doesn't have to set up the entire case, it just has to be part of it.